Welcome to GenAI Case Law, a survey of 50 judicial opinions addressing the use and misuse of GenAI in court documents. I'm Rumay Diamrian, chair of the Beverly Hills Bar Association's Barrister Section, and I'm delighted to introduce today's speaker, Professor Heidi Brown. Professor Brown is a graduate of the University of Virginia School of Law, Associate Dean for Upper Level Writing at New York Law School, and a former litigator in the construction industry. She earned her master's degree in applied positive psychology from the University of Pennsylvania in 2021. Having grappled with extreme performance anxiety as a law student, attorney, and new law professor, Heidi ultimately untangled her fears and embraced authenticity as a powerful asset in teaching and practicing law. Professor Brown has more than 2 decades of experience in practicing law, and she's worked as of counsel with Moore and Lee LLP, a boutique litigation firm with the offices in the DC area and New York City, where she handled all aspects of litigation and arbitration of complex construction contract and building development disputes. She specialized in brief writing for state and federal cases throughout the United States and has mentored junior associates in civil procedure, litigation strategy, and legal writing. And now let's get started with the program.
Thank you so much for having me. Greetings from the East Coast. So I have a ton of material today, so I'm going to jump right in. But yes, I am a law professor now. I teach legal writing, and I am an admitted very late adopter of technology usually. But when ChatGPT sort of rolled into my legal writing classroom uninvited, and it was really like January of 2023, I thought, oh no. I need to get up to speed on this technology. So I've kind of thrown myself all in to really embracing the technology, but kind of slowly introducing myself to it, letting it introduce itself to me, but at the same time, trying to stay on top of how these tools are really being used in our profession, sometimes really well, and then sometimes to a great detriment. So I'm going to kind of cover the case law that's been happening. And as you can tell from my prior slide, I changed the title of this literally today because when I first submitted the title for this, I had only counted up to 50 cases, and now we are up to, by my count, 64, and I don't even think I've caught them all. So today I'm going to focus on, since this is the Beverly Hills Bar Association, I'm going to focus on California state bar rules and judges' rules regarding generative AI, just really briefly. And then I'm going to dive into the case law. I'm going to start with the positive because that's how I roll. And I'm going to talk about how one judge, at least one judge, has been very transparently using AI in his own practice. I'll explain that in a bit, to interpret language. That's how he's using it. And then we're going to dive into the case law involving lawyers and pro se litigants and some experts using and actually misusing generative AI and not checking their sites before they submit documents to the court. So I want to flag all of those for us today. And then, because again, we want to focus on the positive, what can we learn out of this? I'll talk about ethical considerations going forward, our need to get up to speed on these tools so we can avoid those same pitfalls, and then how we might adjust our workflow. Okay, so let's dive right in. Kind of the premise for this is to kind of invite us to have a lifelong learning mindset, and we're kind of required to. So comment 8 to the ABA rule of competence says that members of the legal profession have a duty to, quote, keep abreast of changes in the law and its practice, including both the benefits and the risks associated with relevant technology. So we kind of don't have the luxury of sticking our head in the sand regarding generative AI, even though it might feel awkward or unfamiliar to a lot of us. California's rules are similar. Comment 1 to Rule 1.1 of the competence rule in California says the same thing. We got to get up to speed on the benefits and risks of relevant technology. And then the state bar, actually the Committee on Professional Responsibility and Conduct on Regulation of Use of Generative AI, well, actually those recommendations came out from that committee on regulation of use of generative AI early on. I mean, California was one of the early issuers of state bar rules. And then I just checked, if you're curious about what judges are doing across the country, there are 2 great trackers. One is on Lexis and one is on Bloomberg. And I double checked the Lexis tracker this morning to make sure I didn't miss any. There's one Superior Court judge in California who has issued standing rules regarding AI, generative AI. and then 9 federal judges have issued standing orders regarding generative AI. Now, interestingly, you can check the jurisdictions across the country. Most judges are not saying don't use it. They're saying be careful when you use it. And if you do use it, most judges, at least all the standing orders that I've seen, are requiring us to attach a certification to our filings with the court to disclose that we used it, how we used it, but then also that we have checked every single citation to make sure that the tool didn't accidentally hallucinate law. Okay, so these are the questions, these are the concerns that the ethics opinions across the country and judges have raised. Obviously, the term hallucination is the tech term that the AI gurus have dubbed the things that these tools sort of create out of thin air, but they do it so assertively that we think that these results are real. So we got to be careful about that. And of course, other judges are concerned about us disclosing confidential information to publicly available tools. There's all kinds of discussion about disclosing to our clients that we're using them. Lots of literature going back and forth on whether this will change our billing practices, perhaps if it does make us more efficient. I can tell you, having incorporated these tools into my legal writing classes, so far they are not making me or my students more efficient, because we are adding extra time to check all the tools. But there are discussions about maybe eventually we'll be more efficient. And then you can see on the screen other issues that are being raised in these ethics opinions. Our duty to supervise our more junior employees using these tools, checking for output bias in the output, because these tools have been trained on trillions of words written by humans, which unfortunately also have bias baked into language. And so we need to check and make sure that we're just not using output that has those same concerns. And then my students keep raising the issue of environmental concerns, because these tools do require the use of a ton of energy, and interestingly, even water to cool the computer power. Okay, but let's start with the positive use cases. It's been really interesting hearing about how some judges and then some law professors have been experimenting with this too, have been testing out whether AI can assist in predicting and resolving ambiguities in contract and language interpretation. So I wanted to flag for you 2 really interesting cases that came out last year in 2024 out of the 11th Circuit, so the federal court, 11th Circuit Court of Appeals. So Judge Kevin Newsom, he wrote 2 concurring opinions, one in May 24 and one in September of 24. And I just found these really interesting. So both of these cases were dealing with the interpretation of the plain language or plain meaning or the ordinary meaning of words. So the first case was an insurance dispute, and this was Snell versus United Specialty Insurance Company. And in this dispute, there was an insurance coverage question of whether an in-ground trampoline and a retaining wall that an insured party had installed in his yard constituted landscaping in the context of the insurance policy. And so the majority court ended up rendering its decision, I think actually based on the insurance application, and I believe denied coverage. But Judge Kevin Newsom, or upheld the denial of coverage. Judge Kevin Newsom, though, wrote a really long, I think it's like 26-page concurring opinion, very transparently discussing how he got curious about, in addition to what judges normally do to interpret words or determine the ordinary meaning of words that are in dispute in a lawsuit, judges consult dictionaries, they go through the canons of interpretation. But he thought since AI tools, generative AI tools like ChatGPT and Anthropic's version Claude and Google Gemini, since these things are called large language models, they actually process language and predict the next most logical word and sentences, et cetera. I won't go into all the technical mumbo jumbo now because I will mess it up. But he decided to conduct an experiment to see if he asked these generative AI tools the same question, what is the ordinary meaning of the term landscaping, if it would jive with his judicial interpretation. So, and then he did the same thing a couple months later in a criminal sentencing enhancement case where the court had to analyze the ordinary meaning of a multi-word phrase, physically restrained, in the context of an armed robbery sentence enhancement. So let me go to kind of what Judge Newsom said about his insights in asking large language models like ChatGPT, Google Gemini, and Anthropic's Claude the ordinary meaning of these particular terms that were at issue in these cases. He wrote in both of those concurring opinions that large language models are trained on vast amounts of data, words, that aim to reflect and capture how we as individuals use language in our everyday lives. He definitely acknowledged all the potential upsides of AI as well as the hazards of these tools, which is what the rest of our conversation today will talk about. But he called these generative AI models high-octane language prediction machines, capable of probabilistically mapping, among other things, how ordinary people use words and phrases in context. And so you can go read the opinions to determine how he interpreted landscaping and also physically restrained. But he highlighted in the Deleon case, the physical restraint case, he highlighted the benefit of generative AI tools' ability to help interpret a composite multi-word phrase that a regular dictionary or thesaurus can't help us do, right? Because if you type in physically in the dictionary, it only gives us physically, it won't give us physically restrained. I actually wrote a little article on the platform Medium about how I love using ChatGPT's paid version 4.0 as a super thesaurus for the same reason. I like plugging in multi-word phrases, sometimes even sentences, to get a whole list. Like I'll ask it to give me 10 words that mean, and then I'll type in a really long phrase because I'm trying to capture a particular tone. In case you're interested in what other countries are doing, also on the judges level, I haven't found too much yet in multiple countries, but at least 3 countries people are using generative AI to predict how courts will decide disputes. And then also judges in those countries are using generative AI, not as a substitute for their own judgment, but as a kind of a gut check. So for instance, in the UK, there is an employment tribunal where some analysts are using AI to predict how a court will decide disputes in that employment tribunal. One judge in Cartagena, Colombia, the country Colombia, used ChatGPT to kind of solidify his decision in a healthcare coverage case. And then in Argentina, courts in Buenos Aires are using ChatGPT to draft rulings in really complex administrative and tax matters. I put a citation on here too that an American judge has a Substack blog in which he talks about how judges in the United States might get more involved in generative AI as well. If you're interested in how these LLMs might help us kind of game out whether contracts will have ambiguities or disputes over particular words, the way things are phrased, here's a really interesting law review article by 2 professors called Generative Interpretation. And in this article, they give examples of how they have used large language models to, again, sort of game out or predict whether phrasing in contracts like construction contracts. I was a construction litigator for 20 years. So they're 80-page contracts, right? So in situations like construction contracts or insurance contracts, I think another example in this article was matrimonial settlement agreements. Really interesting just to see how we might use these models to help us prevent ambiguity or conflicts in contract interpretation. Okay, so the real crux of our conversation today, let's get into the cautionary tales. I actually wanted to also point out that all of my images in this PowerPoint were generated using AI. I have a very creative brain, but I have zero artistic talent. But I'm also really tired of just using stock art in my PowerPoints because I teach through PowerPoint. So I just decided I would experiment with AI to create really interesting images. And I've really had a lot of fun doing that to kind of jazz up my presentation material. So this is one of my favorite images on this screen for our cautionary tales. Okay, so let's get into it. When I first pitched the CLE program idea, I called it 50 plus, I think it was 50 cases. As of today, I'm recording this on April 25th. I think today's the 25th. Yes, of 2025. we are up to 64 total cases involving lawyers, pro se litigants, and experts who have gotten in trouble for misusing generative AI in submitting court filings. Now, 30 of those cases, at least by my count, of course, I might be missing some that maybe haven't been published, et cetera, but 30 cases have involved lawyers. So I'm going to break that down for us today. Where did it all begin? All right, so you might have read about the very first case called Mata versus Avianca, which took place in my hometown, the U.S. District Court for the Southern District of New York. So this was the first case that came out. It was June of 23. And in this particular situation, I feel kind of bad for these lawyers because they were the first, but they used ChatGPT to draft a brief because, we were all hearing about it in the news. They tried it out. Unfortunately, they cited AI hallucinated cases in an opposition to a motion to dismiss. Here's where things went really wrong, though. When called out by opposing counsel, these lawyers failed to come clean and disclose that that's what they did. And instead, they, quote, doubled down, to use the court's language, and avoided addressing the issue until 6 weeks after the court ordered them to produce the phantom cases, the cases that didn't exist. So this was the very first sanction case. The court ordered the attorneys to send notice of the court's reprimand to the client, write a letter to each of the judges mentioned in the hallucinated cases. And actually, I can't see my screen because the transcript is popping up, but I think it was a $5,000 penalty in this case, which was a pretty hefty sum for the very, very first case. Okay, since then, though, I've tried to categorize the cases because there have been a range of lawyer mindsets about this. None of them are good. Well, one of them is good. One category of lawyers have immediately admitted fault and expressed regret. Because again, these tools are new to a lot of us. We should know better by now, absolutely, in 2025. But the first category I'm going to focus on is the lawyers who immediately admitted fault and expressed regret. The next category I'll focus on is those lawyers, kind of like the Mata versus Avianca case, in which the lawyers, at least initially, failed to take responsibility or explain themselves. And then there are lawyers who are getting in trouble for willful failure. And then this is my least favorite category because I teach interns and law clerks and junior associates. Some senior lawyers have shifted blame, or at least tried to shift blame, to the more junior folks in the law firm. And we do not want to be doing that. Courts don't like that either. So I'm going to start with the first category, the better category, taking responsibility and expressing regret. Okay, so early in February, I have a Canada case on here because it was one of the earliest situations as well. So in a Massachusetts court, again, a lawyer filed a brief with, or certain filings with AI generated citations that did not exist. And this lawyer, when called out on it, immediately acknowledged responsibility and expressed regret to the court, apologized, etc. This lawyer did talk about the fact that he had delegated the research and the writing to recent law school graduates and a trusted associate, but he didn't blame them. He said he erroneously did not review the citations provided by his more junior team as their supervisor. He knew that he had to take responsibility as their supervisor to check if they were using AI. And so the court did impose a monetary sanction of $2,000, but the court took into consideration the sincerity of the lawyer's contrition. I just wanted to point out the Canadian case because it happened around the same time. Similarly, a lawyer submitted a brief with an AI hallucinated case, but he also conceded the error and apologized and expressed remorse and that he was embarrassed. And so the court found no intent to deceive and just ordered him to pay opposing counsel's costs incurred in researching the non-existent cases. Another case kind of early on in this whole journey of ours in generative AI, another New York case, a disbarred attorney used a generative AI tool called Google Bard at the time, which has subsequently changed to Google Gemini. This disbarred attorney supplied these cases to his lawyer. The lawyer did not independently review them, but just stuck him in the brief and filed the motion. But again, neither the opposing counsel or the court could find the cases because they were hallucinated by Google Bard. This lawyer also, like the others I just mentioned, accepted responsibility for the error and apologized. And I kind of found this a little bit shocking, but since the court found no evidence of bad faith, there was no sanction at all in this case. This one was more the public embarrassment. The court actually wrote in the opinion, the court deemed the attorney's acts embarrassing, certainly negligent, and constituting extreme carelessness. So early on, some judges were feeling like the public embarrassment was enough to deter this from happening again. Okay, so let's shift now to the unfortunate situation of lawyers failing to take responsibility. So in another New York case, I don't know why a lot of these were coming out of New York in the initial era of this, but a lawyer filed a reply brief. This was in surrogate's court, filed a reply brief containing fictitious cases and failed to acknowledge the error. And the court struck the pleading. So that was the result here. The court struck the pleading and scheduled a hearing to determine the appropriateness of sanctions. I really like the quote that I've called out here because the judge said, a simple Lexis search of the cases cited, which takes mere seconds, would have shown this lawyer that the cases that they got through AI were incorrect or fake or non-existent. And so I liked that this judge kind of spelled it out in the opinion that counsel, we have a duty to take minimal time and at least the bare minimum of time and effort to cross-check this information to realize this is happening. More failure to take responsibility. These cases are still from last year, and don't worry, I'm going to mention the cases that are literally happening up until as recent as last week or this past week. Another case this was in the Western District of Virginia, where I took the bar exam ages ago. This counsel filed a brief citing AI hallucinated cases again, and when the court deemed this gross error and asked the party to explain themselves, she failed to explain herself. And so the court noted, this silence is deafening. I kind of thought that language was pretty powerful. And so again, the court issued an order to show cause as to why the attorneys should not be sanctioned. For some of these, I haven't gone back to check to see what the ultimate sanction is because they happened so long ago and some of the opinions aren't published, but I can follow up on this one. Around the same time in the summer of 2024 in Florida, a different lawyer was subject to a very robust disciplinary proceeding for multiple reasons, but one of the ethical infractions was filing papers with, again, hallucinated cases, failing to take responsibility. And this one tried deflecting blame to his client. I think the client had possibly participated in some of the research using generative AI. All right, so now we'll get to my least favorite category, the attempts to shift blame to junior staff. In California, this was an early case, October 20th. Actually, both of these are early cases, October 2023. This was an eviction case in which a law firm submitted court filings containing fake case law, and the lead attorney on the case sort of tried to shift blame to the first-year lawyer in his office who used the generative AI to draft the papers. And interestingly, the court did rule against the law firm and dismissed the eviction suit, but the financial penalty was $999, which a news article about this pointed out said that it was $1 below the threshold for reporting the matter to the state bar. Month later in Colorado, this one had a much more egregious result. The lawyer did the same thing, filed a motion containing cases he found through ChatGPT without verifying their accuracy. He discovered the cases were fake, but did not alert the court. And this lawyer also, at least the article about this said this particular lawyer lied and blamed a legal intern. And so the court issued a stipulation to discipline and suspended the attorney's bar license for 1 year and 1 day. So that was a much more kind of dramatic outcome. All right, let's talk about one case in which an attorney was deemed to have willfully failed to comply with the rules. This was a case in the Second Circuit. So again, back on the East Coast. And this attorney cited fake cases, and the court said, after investigation, the court said that they made no inquiry, much less the reasonable inquiry required into the validity of arguments she presented. So this was beyond just fake cases. This was using generative AI to generate arguments that made no sense. The lawyer ultimately admitted she used ChatGPT. I think in this case, too, there were some other non-compliance issues with the court rules, and the court directed the attorney to notify her client of the reprimand, and this particular attorney was referred to the Second Circuit's grievance panel. So we're seeing more of this kind of disciplinary action. As I mentioned at the beginning, when we jumped on today, many judges across the country have issued standing orders related to generative AI. Again, most are not saying we shouldn't use it, but are saying we must be ethical and methodical when we use it, make sure we check everything. And so no matter what court you're practicing in, definitely check the standing orders, because they all sort of vary in language and in their requirements. Many are requiring a certification or a declaration, like we add certificates of service, or we add different things to briefs depending on the jurisdiction. This particular case was, it's California, September of 24. The judge, I believe, was concerned that the brief was a motion that had a fake case, and the court was concerned that the brief was generated using generative AI, but there was no declaration about such use attached to the filing, even though this particular judge's standing order required such a declaration. Counsel, when asked about it, revealed she did use generative AI to draft the motion, but still didn't explain her non-compliance with the standing order. And so that resulted in a show cause order as well. Oh, I put on this read the syllabus. As a law professor, we're asked so many times questions. I'm like, read the syllabus. So this is the judge version of read the syllabus, read the standing rules. Some cases have simply resulted in adverse rulings, not an additional sanction. In a Texas court case, this one was early on as well in 2023, a lawyer submitted an appellate brief citing non-existent cases, and the court deemed the brief deficient and illogical because of the non-existent cases, and also I believe even just the logic of the arguments made no sense here. This court couldn't determine with certainty whether the attorney had used generative AI, and the court actually resisted the temptation to issue a show cause order or report the attorney to the state bar. But this is one of the very earliest cases that happened in Texas. Back to 2024, similarly, this was also an appellate case. The court struck an appellate brief that failed to comply with the court rules and also contained the fabricated case law, and the appeal was dismissed. So again, adverse outcomes based on citing fake cases and not following the rules. All right, so I will bring us up to date. By my count, there are 12 additional cases already in 2025. And again, I might not be catching all these. My librarian at the law school where I teach, New York Law School, has been so awesome at helping me kind of stay on top of which cases are popping up. And by our count, we've counted 12 more cases involving lawyers. I'm going to get to the self-represented litigants in just a moment. You can see on the screen, these are only 5 of the 12. I've got a couple slides on the additional 12 cases. I won't belabor the point. Like, all of these lawyers on the screen today filed motions or briefs containing non-existent. I kind of like how the language is the thesaurus, or the synonyms for fake cases. We can call them non-existent, fictitious, fake. One court called them phantom cases. And you can see the penalties kind of run the gamut. The United States versus Hayes case was a $1,500 sanction. Another the one in the middle, the highest sanction that I've seen to date was $15,000, because the court issued a $5,000 penalty because there were 3 for each of 3 separate briefs. So that added up to $15,000. Another one was $3,000 for one particular lawyer, and he had his pro hac vice status yanked, and a $1,000 sanction for the 2 other lawyers on that case. And then the $2,500 penalty. So you can kind of see that there's really no, it's all over the map in terms of what financial penalties courts are issuing. Okay, so that's the first 5 of the 12 additional cases I've found in 25. I wanted to particularly highlight this one that happened earlier this year in the federal court in Puerto Rico. Again, a party submitted filings with rampant citation errors. I recommend you read the briefs on this show cause order, because the one party who did not cite hallucinated cases wrote a really well written but somewhat scathing brief about how frustrating it was to see these fake citations, and also that the party really didn't take responsibility. The lawyer for the other side did not take responsibility for this. In response to the order to show cause, the party who used generative AI, and absolutely did, asserted it didn't use AI, but that the errors were due to human oversight under, this is the quote from the case, under significant time constraints. But the court said it is not persuaded, and the court deemed sanctions appropriate given the extent of the errors in the motions. And this is what I wanted to highlight for you: the subsequent time and energy required by both defendants and the court to check the plaintiff's filing. I wanted to really flag this language for us because the court said, rather than showing contrition, the memorandum in compliance, which is what the party called their brief, strikes a defiant and deflective tone, and it contained more erroneous citations. So it was like doubling down on doubling down, which really did not bode well. The sanction was an order to pay the defendant's attorney's fees in relation to the filings, and so the attorneys who did not err are required to submit a fee request, and I think that is still pending because this case came out pretty recently. These are the remaining 5 cases of the 12 new ones. And again, in every single one of these cases, lawyers submitted briefs citing case law that didn't exist. You can see the one on the far right, Coomer versus Lindell in the United States District Court for the District of Colorado, 30 defective citations in that case. Not all of those were fake cases, but miscitings and things like that. And the court, in many occasions, the court suspects generative AI's use isn't 100% certain, but you can see in 2 of the cases, the lawyers were ordered to serve a copy of the judge's decision on their various state bars. One lawyer was not allowed to appear in the case anymore. I think that may have been another pro hoc vice situation. And then again, in the Coomer versus Lindell case, there was another order to show cause why this lawyer should not be sanctioned and subject to discipline. The last case for the lawyers, and I'm going to switch the pro se litigants, the self-represented ones, in 10 seconds. This one I found really interesting. So in the federal court in New Mexico, a lawyer paid a freelance lawyer through a company called Law Clerk, and I capitalized it because that's how it is in the brief, in the court's opinion. So this counsel paid a freelance lawyer through this particular company to write a brief, and the brief contains 6 non-existent cases. And it was shown that those cases came from the use of generative AI. So the court fined the lawyer who hired the freelance lawyer, fined that lawyer $1,500, and ordered that lawyer to send a copy of the sanctions order to the company Law Clerk, required the lawyer to complete a CLE regarding legal ethics in writing or the use of AI in writing, which is what we're doing right now, self-report to the state bar disciplinary boards, and report the freelancer to the state bar disciplinary board. So a big deal in that case as well. As you can tell from what I've described, the results have, again, been all over the map. Financial penalties ranging from that California case of $999 all the way up to $15,000. That's at least the highest one that I've seen, and then the whole range of other actions. All right, so let's now get into the self-represented litigants. So the way the rest of this is going to go for the next half hour, self-represented litigants, I'm going to get into, I think, 2 experts situations. one very persistent law firm who tried to use AI for a purpose for 8 times and was not successful. And then one super recent situation in which a court cited to AI research in a pleading, which is kind of a different category, but I'm going to explain that too. So as of today, again, April 25th, 2025, we have at least, potentially more, but at least by my count, 23 cases in which pro se litigants have submitted case filings with fabricated case law, which obviously adds burden to the work of opposing counsel and the court staff. So I'll start with the earlier ones where the court really emphasized the burden on opposing counsel in courts when, average citizens who are representing themselves are probably using these public models, most likely a lot of the unpaid models too. And some of the paid versions of these models are getting better and better, obviously. But anyway, so let me just dive into these cases. So in these cases, judges either notice that the cases don't exist that are being, in these particular cases, judges are noticing citations to case law that does not exist, or they're noticing really inartful pleadings or just really poorly written pleadings that not, this is interesting. So I don't know how many of you've tried using these tools, but they can actually write in clearly and logically, but not so much necessarily in a legal argument. And so the courts are seeing, it's not that they have typos and mistakes in them like that, or grammatical mistakes, it's that the logic doesn't make sense, or that it's making legal arguments that have no basis in law. And so courts are noticing that and wondering whether these parties have used generative AI. So as you can see on the screen, a couple situations like that where pro se litigants either did submit briefs citing imaginary cases. One cited 24 cases and only 2 existed and did not stand for the propositions asserted. I will tell you though, in the pro se litigants cases, the courts have been much more reluctant to impose financial sanctions or any sort of other penalty, but I'll get to some adverse rulings in a moment. I wanted to quote the language from these judges because I found this language kind of interesting. As a person who always went up against opposing counsel in my construction cases and never encountered a pro se litigant in my construction cases, I thought this language was informative to me at least. So Magistrate Judge Susan Rodriguez acknowledged the, quote, latitude that is afforded pro se litigants, but did indicate reliance on generative AI tools may result in sanctions or penalties when used inappropriately. Similarly, another judge called the custom of affording pro se litigants special solicitude, but also said the court won't look kindly on similar infractions in the future. And then another judge, Angela Quigless, said litigants who use generative AI to draft their brief should not rely on our continued magnanimity. So there is a statement that we afford them latitude, pro se litigants, special solicitude. There's been an effort to be a little bit magnanimous, but that is not going to last. More judges have said the same thing. Any further filings by this particular pro se litigant will result in sanctions or may result in sanctions. Judge Eric Schumacher said, we caution plaintiff that his pro se status does not excuse his failure to check the legal citations he offers to a court. And then Judge Rosalind Silver told the litigant, you must comply with, we have specific rules about this, and please check the rules before you file in our court. Something for our profession to think about. Magistrate Judge Gary Stein noted the possibility that pro se plaintiffs might not be aware of the risk that ChatGPT and other models are capable of generating this fake case law, but also they also might not have access to our paid versions of Westlaw or Lexis, so they can check the citations. So that's something that we, as a profession, should think about. How do we make sure that pro se litigants can get access to tools where they can check the citations and not get in trouble for just relying on public ChatGPT and other tools? Some of the results did result in dismissals of these self-represented litigants' cases. You can see in the Western District of Washington, the court dismissed a matter when there was case law that was hallucinated. Oh, the same lawyer. Remember the case I mentioned about the willful failure? So this was the same lawyer appearing pro se, representing herself in a lawsuit against Delta Airlines back in New York. And the court expressed serious concern regarding this litigant's citation of a fake case, acknowledged that special solicitude custom, but noted this is a lawyer. This is not your non-lawyer self-represented person, and she had been practicing law for 2 decades, so the court dismissed the complaint. Interestingly, in the third case on this screen, Missouri Court of Appeals, this is the case in which there were 24 case citations, but only 2 existed and still didn't stand for the propositions asserted. The court dismissed the matter and imposed a $10,000 penalty on this party for filing a frivolous appeal. There may have been some other stuff going on there I'm not aware of, but that was a pretty significant financial penalty. Okay, so again, 4 more cases in December. These cases, pro se parties continuing to file briefs containing hallucinated sanctions. Again, a couple of these courts declined to impose monetary sanctions, but issued adverse judgments against these parties. One court, presuming AI use, dismissed the parties' claims. You can see, another court dismissed the consolidated appeal, and actually the Gutierrez case involved a lot of transgressions, not following the rules, so that lawyer was barred from further pro se filings. Okay, and then 2 more cases, bringing us up to almost the present. 2 more cases in March, just last month. This one of these parties, again, we're still in the self-represented litigant category, submitted a brief containing what the court said were alarming miscitations. The court suspected AI misuse and emphasized again, this is a burden. This is a burden on the court. It's a burden on opposing counsel. And the court, this was again back in the District Court of Puerto Rico, acknowledged this is becoming an increasing problem among pro se parties. In the Court of Federal Claims in March, similarly, self-represented litigant cited hallucinated cases. And I kind of liked the way this court framed it. The court said plaintiff's briefing built on AI-generated cases that stand for legal propositions in direct contravention of actual case law is the epitome of baseless. But once again, the court issued a warning because it was a self-represented litigant instead of imposing sanctions. 2 more recent cases in April. I think I have these 2 and then 1 more, and then we'll shift to experts. 2 more recent cases in April. We're back in Texas. This litigant filed objections to a magistrate judge's report, but cited a non-existent case, which made the court suspect generative AI misuse. And the court just reminded the pro se litigant that they, just like an attorney, are bound by the court's rules. There's no getting around being bound by the court's rules. So the court overruled the objections to the magistrate judge's report and dismissed the case with prejudice. Same thing in the On versus Archblock case. Oh, this what is interesting. I put on here that this judge suspected AI use because there were problematic citations in the motion that the self-represented party filed. And they failed to comply with the certification requirement of AI use. In this judge's standing rules, there was a certification requirement if the party used AI. Suspecting AI use, though, the judge tried to find the cases themselves using Westlaw and ChatGPT, and couldn't find the case. The court does a really nice job in this case of discussing both upsides and risks to generative AI. So again, not saying that these tools are terrible for everything. They're not. I find them really helpful personally in my own. I love writing, so I don't outsource my writing to generative AI, but I really love how it boosts my creativity and word choice. Like I mentioned, using it as a super thesaurus. The court in this On versus Archblock case highlights some of the upsides, that it's efficient in summarizing documents, etc. You can read the opinion if you want to know the other upsides discussed in that case, but also the court identified the risks. And because this particular litigant, like one of the cases I mentioned at the very beginning, doubled down and was not forthright in their use of AI, the court denied the person's motion. last case involving a self-represented litigant happened just on April 15th, 2025, so 10 short days ago. Eastern District of Michigan. This was a self-represented litigant. I don't know how to pronounce the Latin for the proceeding. I forget how to say it, but you can look it up. An indigent litigant hand wrote at the bottom of a typewritten brief. This motion was done by AI. They wrote the little I. And then the court wrote, that is a bad idea in one very real and important sense. This plaintiff now will be held responsible for the content of his filings under Federal Rule 11, which we all know requires us to verify that we're signing based on the accuracy of all facts and law in our brief, whether we use artificial intelligence or not. And then the court emphasized they will not accept AI as an excuse for inaccuracies. Okay, we've already talked about the Gutierrez case, but I thought it's interesting that this was the first time I had seen the word phantom case law in the case, and it was because the opposing counsel wrote a notice to the court of phantom case law, pointing out that they suspected that the case law cited in the pro se plaintiff's documents did not exist. This was the case in which the court ended up barring that particular plaintiff from further appellate pro se filings in the particular probate action because he had violated a lot of the court rules. All right, I forgot that I included a slide on two more cases in which the judges suspected generative AI in the context of poor briefing, but because they had really no proof, they just noted the possibility. Again, at SDNY, I believe this is Magistrate Judge Ona Wang. I took my students to observe court because she was holding a status conference in an interesting AI case. And I believe this is Judge Wang said that she has no general prohibition on the use of AI, but this particular party's brief was not helpful to the court. Okay, so let's switch gears a little bit and talk about experts. And I wanted to talk about two cases, to my knowledge, in which experts have stumbled or fumbled by trying to rely upon or actually, the first one is intentionally trying to rely upon AI to support an expert opinion. Back in New York, in the surrogates court, actually, I said this was a recent case, but now it's already been about 6 months. But an expert witness, this was in, let me go to the next slide. An objector, so a party who is objecting to the accounting of an estate in an estate administration scenario, hired an expert witness to render an opinion about damages calculations related to real estate property. There were some allegations that the trustee had mismanaged either the timing of the real estate sale, I believe, or the value of the property. And this particular expert had used another AI tool, generative AI tool, Microsoft Copilot, to not to do his calculations for him, but to cross-check his calculations. And he submitted his conversations with Microsoft Copilot as part of his expert report, or I believe as maybe as part of his expert testimony. And the judge was interested, but deemed the damages calculation done by Microsoft Copilot as unreliable. And here's why. Because the expert didn't take the extra steps, or couldn't take these steps perhaps, of explaining how Copilot functions, how it produces its output, what sources it relies upon, or how the resulting calculations in this case met the reliability standards applicable to the expert opinions. So the court, I think the court even tried to experiment with Microsoft Copilot to see if it was repeatable, so and therefore more reliable, and the court deemed it not reliable. So this particular judge accentuated, like that verb, I wrote that verb, and then quote, counsel has an affirmative duty to disclose the use of artificial intelligence in the context of expert reports, and then any proposed evidence would be subject to a Fry hearing. The standard in New York State Court here was the Fry standard prior to its admissions. I wanted to take just a second to refresh our recollection about expert testimony admissibility standards based on 3 different rules, and then I'll explain the other expert scenario that went awry because of generative AI. Fry standard, You might be familiar with this, but scientific evidence, expert evidence must be based on a principle, procedure, or methodology which has, quote, gained general acceptance in its particular specified field. So unless we can show that generative AI generated damages calculations have gained general acceptance, they're not going to meet the Fry standard. The Fry rule says it doesn't have to be universally accepted or unanimously endorsed in the field, but it must be reasonably relied upon and generally accepted as reliable, which the judge in that prior case I mentioned implied that the Microsoft Copilot damages calculations would probably not meet that standard. The court will, under the Fry standard, will consider judicial opinions, scientific or legal writings, or experts other than the proffered expert in analyzing the reliability question. As we all know, Federal Rule 703, Federal of Evidence 703 talks about reliability as well. Under FRE 703, so in federal court, an expert's opinion must first be helpful to the trier of fact, must be based on sufficient facts or data, must be the product, here's the reliability, must be the product of reliable principles and methods, and reflect a reliable application of those principles and methods to the facts of the case. And then our trusty old Daubert standard or Daubert standard, we have to show if we're submitting an expert report or expert testimony in federal court or in a Daubert jurisdiction, the court will analyze whether the expert's technique, theory, or methodology can be and has been tested, whether it's been subjected to publication and peer review, whether it has a known or potential error rate. The court will look at whether standards exist and whether, again, the technique, theory, or methodology has attracted widespread acceptance within a relevant scientific community or within the relevant community of the industry or subject matter of that expert. Okay, so getting to the next expert situation, you may have read about this in the news. This one is, again, just frustrating. So here's the situation. So in Minnesota, there was new legislation proposed to ban what's called deep fake technology to influence an election. I don't know the technical definition of deep fake, but basically it's using technology, likely AI, to make us think that a particular person is saying something about a particular thing, public opinion, etc. So Minnesota's Attorney General hired or engaged an expert to opine in favor of this new legislation to ban deep fake technology to influence an election. And this expert had massive technical expertise. This person was the founding director of the Stanford Social Media Lab. This particular expert submitted a declaration in support of the law preventing deep fake technology to influence an election. But unfortunately, the declaration from this expert cited academic sources that do not exist. So the lawyers challenging the law, challenging the anti-deepfake legislation, suggested the sources were generated by an LLM. And as it turns out, the expert, he was very forthcoming. He admitted that he used an AI tool to help him as part of his drafting process, which many people do. Like I said that I use AI to help me come up with different vocabulary, et cetera, check my grammar sometimes. Problem was this particular expert had put placeholders in his declaration where he was going to go back and fill in citations later. But as it turned out, if I'm reading the opinion correctly, ChatGPT, I forget which tool he used. I believe it was ChatGPT, but anyway, the AI tool filled in the citations for him. And he didn't notice that the LLM had done that for him. And he didn't go back and check those newly inserted citations using the technology he usually uses for academic citation checking. And so those fake citations slipped into the declaration and got in front of the court. And so the court excluded this expert's testimony and saying that the citation of fake academic sources, quote, shattered his credibility. The shatter verb was the court's language. So not good. Okay, as recently as 3 days ago, April 22nd, 2025. Actually, I don't know why I'm being so dramatic. This case is not that dramatic. This is just an interesting recent case that happened 3 days ago. Yelp versus Google. So two kind of technology related companies. Yelp is asserting an antitrust action against Google. Yelp is claiming that Google has a monopoly on local search services online. Procedurally, Google filed a motion to dismiss Yelp's antitrust action. And in the pleading, in the complaint, I believe, Yelp pleads this quote, while exact figures can vary, it's generally estimated that Google holds well over 90% of the market share in local search. And then it cites, or sorry, I haven't looked at the exact complaint, but the court opinion on this issue says this fact was generated by a query to Google's Gemini AI tool. Google, in filing a motion to dismiss, argues that citation to an artificial intelligence tool is not a plausible allegation. Interesting. The court said Google's concerns, in the court's ruling on the motion to dismiss, the court said Google's concerns about, quote, pleading by bot are legitimate, but neither the federal rules of civil procedure nor the local rules prohibit such use of AI, which is true. We're not prohibited from using AI. So at this point in the case, the court declined to address any perceived to be negative implications of Yelp's use of AI in the pleading. So we can stay tuned and see what happens with that case. Our final category, before I get to kind of what we should do about all this in our last few minutes together, one particular law firm, again, back in New York, it represents parties in cases alleging Individuals with Disability Act, IDEA, claims against the New York City Department of Education. So 8 times, so basically 8 times this particular law firm won on behalf of their client. They won the IDEA claim against the New York City Department of Education, and under the statute, they're entitled to recover attorney's fees. But 8 different times, it attached dialogue with ChatGPT, prompts and responses to support assertions of alleged prevailing market rates in its attorney's fees request. So the ChatGPT was an attempt to prove up the prevailing market rates of the attorney's fees amounts. Eight times this law firm did this, and 8 times all the judges, each judge in all 8 of the cases rejected, disregarded, and declined to consider or credit the ChatGPT quote evidence in support of the law firm's fee requests, based on, going back to our discussion about evidentiary standards, ChatGPT inventing false information, the tool's propensity to fabricate information, and its current reputation. This was all in 2024 as an unreliable source. I think the last case I found on this case was maybe October of 24. Language in 2 of the judicial opinions, though, acknowledged these decisions were based on the existing state of generative AI. Judge Paul Engelmeyer, in one of these cases, said, barring a paradigm shift in the reliability of this tool, the firm is well advised to stop doing this, stop referring to ChatGPT in future fee applications. But he was talking about maybe eventually, I mean, I interpreted this as maybe eventually there'll be a paradigm shift. And Magistrate Judge James Cott says ChatGPT, at least in its current iteration, and that was back again in 2024, should not be utilized to support a fee application. I know we're coming up against time, so I will make some recommendations, and then I'll see if there are any questions, and people can stick around for a few extra minutes if you're curious about the questions, but otherwise, everybody else in 2 minutes, I think, can log off. How can we be part of the solution? Basically what we're doing right now, what we've just been doing for the last hour. Let's understand generative AI tools' current limitations related to legal research. I mean, even our legal professions tools are not perfect, so we really need to understand what these tools are good at and what they still need to grow on. We have to incorporate site verification protocols into our workflow. We don't have the luxury of relying on these tools. We have to check every single site. We can use them to generate citations, but we have got to check every single site. We also, as we're doing today, should provide generative AI literacy training for members of our institutions, offices, and communities from entry level all the way up to senior leadership. I don't know about you, but if you've read Dr. Ethan Mollick is a professor at Wharton, and he's is really linking education and AI, and he sets down what he calls sort of the 10-hour challenge. All of us, he said, all of us should play with these tools for 10 hours to understand for our own purposes what they are good at and what they are not good at, because we learn a lot in 10 hours. So I want to kind of re-up the 10-hour challenge and use it for things that are even just fun or interesting in your life that have nothing to do with your work, and you'll learn a lot. Continuing on with how we can be part of the solution, let's enhance open and transparent communication up and down our staff and supervisory systems to make sure that people aren't using this without our knowledge, but if they are, we're all in communication about it. Let's commit time to making sure that we edit any generative AI generated legal writing to ensure our work product is helpful to judges and our legal readers. You saw the cases I flagged in which judges said these briefs just are not helpful. Let's make them helpful. And then absolutely, we need to comply with judges' standing orders related to certifying. On the pro se part, I mean, our profession can probably do more to educate the average citizen about the existing perils and relying on public generative AI tools. And somehow, maybe we can help provide free or cost-effective methods for pro se litigants to verify cases that they have found as well. And then let's remind our experts about the evidentiary standards that will absolutely be applied to opinions and calculations derived with the assistance of generative AI tools. So I think that is it. I've written some articles about these that are in the materials, and please feel free to reach out to me if you have questions or want follow-up, or you want me to come talk to you and your law firm more about these particular topics. Okay, so let me see if I can find the Q&A in my toolbar, and I will see if you have any questions. I'll stop the share. Q&A. Okay. All right, great question. How can one reasonably comply with ABA Rule 1.1, Comment 8, and similar rules when technology is advancing so exponentially that once one is versed enough to comply, that the next thing is already past its shelf life? Great question. I mean, I think these things are evolving on a daily basis, but we can't just wait until they're, quote, perfect. We really do have to try. That's why I like Professor Mollick's 10-hour rule, because if we just commit to experimenting with these tools, both the public facing ones, and definitely don't put any confidential information into those, but also the legal professions ones, and testing them out, that, in my opinion, I mean, I'm not an expert and I'm on professional ethics compliance, but I would say as long as we are staying abreast of benefits and risks associated with these tools, we don't have to be experts in these tools. And I would go ahead and read the standing rules in your jurisdictions, because that's what the judges are saying too, like, and the ethics opinions from various jurisdictions. We're not supposed to be tech experts, but we also can't avoid getting to know these tools until they're, quote, perfect, because we just don't have that choice. So I would recommend playing around with them. Okay, and second, is AI in contract interpretation capable of taking into account canons of construction, some of which are codified in California? So I have a whole other seminar on prompt engineering, but if you give instructions to the AI tools, it will apply canons of canons of construction. There are some great tools. Well, I'm not going to say they're great because I haven't really tried them. There are a plethora of contract drafting tools and contract interpretation tools that you can experiment with. And I think that that would be a good experiment to undertake as well. But I do have a whole ton of stuff on prompt engineering if you're interested in learning how to teach the tool the canons of construction. And then, okay, is there an AI app that can be used to verify the existence of actual cases behind citations in an AI-generated legal writing? I do not know, but I think you can probably test out whether you can upload a document containing citations and run it through the site checking tools on Westlaw Lexis. I have not tried that, but I would recommend that we experiment again as part of our 10-hour challenge. All right, last question, I think, by checking citations, even if generated by AI, what type of checking are you suggesting jeopardizing through digital means, wondering if case citation check embraces AI. I mean, what I mean by this is if you've used any AI tool, whether it's public, whether it's Westlaw or Lexis, whether anything, we have to do our due diligence as lawyers, no matter what. So I would say, take the citation, type it into a tool that we know has pulls from real cases like Westlaw or Lexis and other ones that are out there, I suppose, and read the case. We can't just rely on the citation or the AI tools to also verify that we can't rely on the AI generated content as the case saying what it's proposed to be saying. We still need to go back and read these cases. So that's why I know there's a lot of hype out there right now about how these tools are supposed to make us super efficient. My personal opinion, I don't speak on behalf of anybody except myself, is that initially the research part is not making us faster because we still have to check everything. Eventually it will get better and better and we might get more efficient at it. But now I would say don't err on the side, just do it. Check every case citation, still read the cases, make sure these are actual cases coming from real publications or the sources that we trust with like a Westlaw or Lexis citation, even if it's an unpublished case on Westlaw or Lexis. So that's my answer to that. Keep checking, keep checking, keep checking. If you have any questions additionally, please feel free to reach out. You have my contact information. I love kind of introducing people to generative AI literacy. I love teaching prompt engineering. And again, I would just want to put out there, like, I love writing. I identify as a writer before my fancier titles of professor or lawyer. And so I'm never going to totally outsource my writing to AI, but I do enjoy using it to turbo boost my creativity. And just as kind of a supplement or a companion, but not a replacement. So I will leave it at that. Thank you very much for your attention. And I know I've thrown a lot of information at you today, but hopefully we all learned something.